Okay, can I see that Ferris? Mr. Blumberg, are you able to hear me okay?
Yes, I am, Judge. Thanks.
Okay. All right, we'll go on the record in Ferris versus Ferris, file number 2419904. The record should reflect that Mr. Blumberg, you're appearing on behalf of Mr. Ferris, is that correct?
Yes.
Okay. Mr. Blumberg's present on behalf of plaintiff Mr. Ferris. This hearing was set for 9 a.m. It's now 9:05. I don't see Ms. Ferris signed in. This hearing was set today by the court. Parties are required to attend the SMILE program by order of the court through the friend of the court. And it appears that at least up until the time that this hearing was set, Ms. Ferris had not attended that. Ms. Krause, do you have any update on that for me?
No, outside of what was ordered for her to schedule them, but we haven't had contact with her.
Okay. Looks like, is this mail? Okay, so just for the record, the court would note that the notice of the next hearing between the parties, which is set for November 10th in front of the referee, that notice was returned as undeliverable to the court to Ms. Ferris. So apparently we don't have a good address for her. But regardless, the court will note her failure to appear today. The court will set this for a contempt hearing at its next available date. If Ms. Ferris fails to appear for the contempt hearing or fails to provide adequate justification for her failure to attend the SMILE program, if she hasn't done it by that time, then the court will impose sanctions on Ms. Ferris that are appropriate to the case. Mr. Blumberg, was there anything that you wanted to be heard on regarding that issue?
Judge, I know that she has moved into a new residence with her boyfriend. I can try to get that address to the front of the court. I think we may have it.
Yeah, that would be great if you or your client has information on her current address, because we must still have the old one. She has not updated it.
Right. Okay, I'll do that.
Okay, otherwise the parties will proceed as currently scheduled in the front of the court on November 10th. Mr. Blumberg, anything I can address for your side today?
No, thank you very much.
Okay, thank you. That's all for today, and you're free to disconnect at this time. So if you can just put in the notes to set for a contempt hearing on the court's next motion day in November. I can't believe it's gonna be November already.
I know.
So, Ms. Krause, we're gonna notice that for a contempt hearing in November.
For November?
Yeah, on the court's motion day.
Okay, I appreciate that. Thank you.
Thank you. Okay, our next hearing's at 9:15. I don't see the parties yet, so we'll just take a short break and we'll come back on the record at 9:15. Okay, we have both parties connected. We'll go on the record now in Morrison versus Morrison, and this is file number 2319363. The record should reflect both parties are connected by Zoom video. This was to be set for a final hearing today. I do not see a final proposed judgment. So I guess I just need to see where the holdup is. Ms. Spillane, do you have any information that you can provide me with on that?
Sure.
With
Earlier
what-
last week, Mrs. Morrison came in and presented incorrect paperwork, incomplete paperwork. So I gave her a fresh packet along with a printed off copy of her child support order so that she could complete it. The plan was that she was going to give it to Mr. Morrison and he was going to drop it off prior to the hearing today. He came into our office about 8:30 or so, and it was still incorrect. So it needs to be completed and revised still.
Okay. Were you able to let Mr. Morrison know what the corrections needed to be?
I did, sir.
Okay, so Mr. Morrison, will you be able to take care of those things?
Yes, I should be able to get them taken care of.
Okay. All right. Ms. Morrison, did you have any questions at all?
No, Your Honor.
Okay. All right. Well, it sounds like we're narrowing in on a final resolution here. So I'm going to set it for one more hearing next month. And we'll proceed at that time. Ms. Morrison, do you have any questions?
No, Your Honor, I did just want to apologize for prolonging things a little bit longer. This last month has been rather chaotic with everything, and I just look forward to completing this, and I just want to thank you for your time.
All right. Thank you. Mr. Morrison, did you have any questions?
No, Your Honor.
Okay. All right. That's all for today. You're both free to disconnect. Thank you.
Thank you.
Thank you, Your Honor.
Okay, Mr. Blumberg, do you have your client with you there, or is he signing in separate?
No, he is here in my office.
Okay, great. All right, we'll go on the record then in Haskell versus Haskell. This is file number 2218880. If I could just have both counsel put your appearances on, please.
Certainly, Your Honor. Zach Backlund on behalf of the plaintiff in this matter, Aubrey Haskell, who's also appearing by Zoom.
Good morning again, Your Honor. Elliot Blumberg on behalf of David Haskell, who's appearing from my office.
Thank you. This is set as a status conference here today. Mr. Backlund, on behalf of plaintiff, can you just kind of update me on where things are at?
Certainly, Your Honor. Since last time we met, Mr. Blumberg and I and the parties attended a hearing with the friend of the court. That was September 24th. During that hearing, the referee set us for an evidentiary hearing on December 3rd at 11 to go over the arrears and potential credit for direct payment, which has been in front of us here as well. I believe Mr. Blumberg and I both provided information to Shasta and Dawn over at the FOC regarding our take on the child support orders, the effective dates, and the potential arrears. And what we're going through now is the potential credit for those arrears as we have in front of you, Your Honor. So that's where we're at.
All right, thank you, Mr. Blumberg.
I would agree with that representation made by counsel. Those are the current issues. We're trying to ultimately resolve the last issue from our perspective, which has to do with the repairs to the home that was awarded to Mrs. Haskell. I'm hopeful that with this hearing coming up, we can resolve the outstanding child support issues and get to the last remaining issue. And hopefully we won't need to come back before you to have that resolved. So that's where things are at. Unfortunately, we're still not at the finish line.
Sure. Okay. So it sounds to me like if the court sets this for a potential final hearing in January, that'll be, a couple of weeks after that hearing or a month after that hearing in front of the court. If the parties have not been able to resolve the other issues outside of the child support issue, then at that hearing, we can just set an evidentiary hearing date so that we can get it resolved. I think by that point, if you don't have an agreement, I think it's probably time to set it for a hearing before the court. And if you're able to agree, then we can use that date to finalize things. Mr. Backlund, any objection to proceeding that way?
No objection. That sounds appropriate to me, Your Honor.
Mr. Blumberg?
No, that's just fine. Thank you.
Okay, so I'll put that into a status conference order, and then we'll set out the notice of, send out the notice of date and time of that hearing in January. Mr. Kraus, was there anything that you needed to add?
Nope, I just wanted to make sure there wasn't any questions for me in regards, but it looks like all the bases were covered.
Okay, all right, thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Thank you.
Mr. Cotton, is that you joining us by phone?
Yes, sir.
Okay, great. Okay, so we'll go on the record in Cotton versus Cotton, and this is file number 2319201. If I could have both counsel put your appearances on.
Good morning, Your Honor. Jennifer Guzman, Kayla Cotton, who's present with me in my office.
Good morning, Your Honor. Attorney Katie Komorowski on behalf of the defendant, Mr. Ty Cotton, who is present via Zoom.
Okay, I have this as the date and time for entry of a judgment of divorce in this case. I know the parties had some questions about how that would be structured, but I believe my office did receive a signature copy this morning that's been signed by the parties. So are we ready to take proofs, Ms. Dukes McCoy, from your side?
Your Honor, the court may be mistaken. I have a case right after this one with the court. We don't have signatures from all the parties in this matter.
Your Honor, I spoke with my client over the weekend. I had not heard back from the court, and so I added the language that my client was comfortable with at the signature page, and I had permission from him to sign that. I signed it for him on his behalf with his verbal permission. I signed it myself, and I emailed it to Ms. Dutz-McCoy in the court before the hearing. And I did notice that Ms. Dutz-McCoy nor her client signed her proposed judgment of divorce that she filed, nor on her motion for the entry. So I think we are waiting on the plaintiff to sign.
Well, I stand corrected, Your Honor. I do see that in my email at 9:30. I didn't check on while we were waiting in the waiting room. So, I see Ms. Komorowski, a signature on the child support order.
I don't believe that we're required to sign that. I believe the judge can sign that for entry. We did not receive an updated calculation from the front of the court as ordered. That was part of the recommendation of the referee, Your Honor, and you had upheld that recommendation after our objections, and we did not receive an updated calculation. So the numbers on there that Ms. Dutz-McCoy put on there are not reflective of any updated calculation. But we are ready to enter the divorce.
All right, I think what I'm gonna do maybe is put the two of you into a breakout room, let the two of you have a discussion here and see if we could take proofs and finalize this today, or if there are things that need to be addressed. Ms. Kraus, was there anything that you needed to jump in on here?
Yes, in regards to the final judgment, so the order after the hearing on July 25th that was signed on 8/4 from your office, our office didn't receive that, a copy of it, until September 8th. The friend of the court approved the judgment that's in question that I believe that you have on August 26th. So based on that information, my assumption was there was an agreement met in regards to the medical, because the VA disability was already input, and there's been no information regarding other than the plaintiff has a medical state grant, and I inputted the information from healthcare in regards to that information. So my assumption was because of that judgment, there would be no additional recommendation done because of that.
And the child should not be on Medicaid. The child has TRICARE. The child will continue to have TRICARE. So that was the question. Why are we, and I, quite frankly, I don't believe that myself or my client want to argue over a $10 difference at this point. We can just file something this week to have it adjusted if that's what we need to do, if it's a $10 adjustment. But that's not appropriate. He's covering the medical, not her. So he should not have to pay her an extra $10. And it was clear during the front of the court hearing that that $10 was paying for the plaintiff herself's medical, which he's not required to pay for.
Okay, well, like I said, I think I'm going to include you in on this, Ms. Kraus. I'm going to put the three of you into a breakout room and let you have a discussion here off the record and see if we can get to the bottom of this. So I'm going to do that right now.
Thank you.
I think I lost Ms. Dutzman-Coy. Okay, here, hold on one second. Okay, we've got everybody reconnected. Ms. Dutzman-Coy, on behalf of plaintiff, I'll start with you. Were we able to figure things out?
I think we were, Your Honor, and I believe that we're ready to proceed with the entry of a judgment of divorce and the uniform child support order.
Okay. Ms. Komorowski, do you agree?
Yes, Your Honor.
Okay, so Ms. Cotton, if you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you. You can lower your hand, and Ms. Dutzman-Coy, if you'd like to proceed, please.
Thank you. Ms. Cotton, would you please state your full name for the record?
Kayla Noel Cotton.
And you are the plaintiff in this divorce proceeding?
Yes.
And you commenced this action by filing a complaint for divorce on February 2nd, 2023?
Yes.
Were both you and Mr. Cotton residents of the state of Michigan for at least 180 days before you filed?
Yes.
Were you both residents of Otsego County for at least 10 days before you filed?
Yes.
And your spouse, the defendant, is named Ty Cotton, is that correct?
Yes.
And you and he were legally married on September 29th, 2009?
Yes.
Where were you married?
Petoskey.
Petoskey, Michigan?
Yeah.
Were you married by a person licensed to perform marriages?
Yes.
Your legal name before the marriage was Kayla Marie Ulrich, is that correct?
Kayla Noel.
I'm sorry, Noel, excuse me, I knew that. Noel Ulrich, correct?
Yes.
Are you asking the court to restore your last name to Ulrich?
Yes.
Okay, and that's Ulrich?
Yes.
You and your spouse have one child together, correct?
Yes.
And all your child-related matters have now been resolved by the court?
Yes.
To your knowledge and belief, are you currently pregnant?
No.
Has there been a breakdown of the marriage relationship to the extent that the object of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Do you believe there's any chance for reconciliation?
No.
As to property, those matters have been resolved by or otherwise resolved by the court, is that correct?
Yes.
Are you going to receive spousal support?
No.
Do you understand that the same is forever barred and you cannot return to the court to request that in the future?
Yes.
Are you asking the court to enter a judgment of divorce and the uniform child support order today?
Yes.
Okay. I don't have further questions for Ms. Cotton, Your Honor.
Ms. Komorowski, did you have any questions for Ms. Cotton?
I do not.
Did you wish to take any testimony from your client today?
Yes.
Okay, Mr. Cotton, are you able to hear me okay?
Yes, sir.
Can you raise your right hand and let me know once it's raised?
Sir.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand, and Ms. Komorowski, please proceed.
Could you state your name for the record?
Ty Gatewood Cotton.
And you are the defendant in this case, correct?
Yes, ma'am.
Were you able to hear the plaintiff's testimony?
Yes.
Do you agree with the statements she made?
Yes.
And during your marriage, you served as active duty Armed Forces Marine. Is that correct?
Yes. Yes, it is.
And that overlapped the marriage sufficient for DFAS to pay part of your military retirement directly to the plaintiff. Is that correct?
Yes, about a month. Yeah.
And then the court had decided under the property provisions that the plaintiff would receive 35% of your military retirement and you would receive 65% of your military retirement. Is that correct?
Yes.
Okay. And have you requested spousal support?
No.
Are you paying spousal support to the plaintiff?
No.
Do you understand that the same is forever barred?
I don't understand that one. No.
Do you understand that neither you nor the plaintiff can request spousal support in the future after the divorce is entered?
Yes. Okay. Yeah.
Okay. And do you agree that the objects of matrimony have been sufficiently broken and destroyed that there remains no reasonable likelihood that your marriage could be preserved at this time?
Absolutely. Yes.
As for the child-related matters, do you agree that the court has decided those in this case?
Yes.
And the remainder of the property provisions you have decided with Ms. Cotton, the plaintiff of the case, during a mediation?
Yes.
Okay, I don't have any further questions, Your Honor.
Thank you. Ms. Dutzman-Coy, did you have any questions for Mr. Cotton?
I do not. Thank you, Judge.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties in this case. The court will grant the divorce and will sign that judgment. Ms. Dutzman-Coy, anything further that I need to address for your side today?
No, thank you.
Ms. Komorowski?
No, Your Honor, thank you.
Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
Thank you.
All right, we've got everybody connected on Meyer versus Meyer. That's file number 2419940. If I could have counsel put your appearances on, please.
Morning, Judge Elliott Blumberg on behalf of Melinda Mayer, who's appearing via Zoom from my office.
Good morning, Your Honor. Travis Grown on behalf of the defendant, Alex Mayer, who I see is present via Zoom, Your Honor.
Okay, this is set for a status conference today. Mr. Blumberg, on behalf of plaintiff, could you tell me where things stand with this file?
Yes, Judge. I think the parties have resolved all of the issues in this case. There is a consent judgment of divorce that has been circulated. Mr. Grote asked for some revisions. I think we've made those. I believe everybody has signed the consent judgment. I don't know, I don't believe the friend of the court has reviewed it yet or approved it. There's also a motion to opt out of the friend of the court services. I know the advice of rights form has been executed by the parties. So I guess it would be my intention if the court would allow for us to take the proofs, and until the judgment's approved by the friend of the court, then we could get it entered.
Okay, Mr. Grote?
I would agree, Your Honor. We did execute the judgment of divorce just moments ago electronically.
Okay. And do you have any objection, Mr. Grote, to taking proofs today?
I do not, Your Honor.
Okay. And Mr. Blumberg, is Ms. Mayer there with you?
He is right there.
Okay, great. So Ms. Mayer and Mr. Mayer, I'll swear both of you in at the same time. If you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You speak.
Thank you. Yeah, you can both lower your hand, and Mr. Blumberg, yeah, thank you. If you can have Ms. Mayer speak up, and please proceed with your examination.
Thank you. Melinda, can you state your full name for the record?
Melinda Daniel Meyer.
And you are the plaintiff in this action for divorce, is that true?
That is true.
You had filed a complaint on December 11th of 2004 in this county, alleging, among other things, that you had been a resident of the state of Michigan for at least 6 months before you filed. Is that true?
That is true.
And that you had been a resident of Otsego County for at least 10 days immediately preceding the filing of your complaint. Is that true?
That is true.
You also alleged that on February 15th of 2014, you married Alexander Stephen Meyer in Ann Arbor, Michigan. Is that correct?
That is correct.
And that ceremony was performed by an individual who is authorized to perform marriages. Is that correct?
That is correct.
There are 3 children born of this marriage. Is that correct?
That is correct.
And you and Mr. Meyer have come to an agreement whereby you're going to share both joint legal and joint physical custody of these children. Is that correct?
That is correct.
And you've arrived at a parenting time schedule that you believe is in the best interest of your children?
That is correct.
Okay. You alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed this action?
That is true at the time of filing the action.
And is that also true today?
That is true today.
You are not currently pregnant, are you?
I am not currently pregnant.
Now, you and Mr. Meyer came up with a property settlement agreement that divided up the marital assets as well as the marital debt. Is that your understanding?
That is my understanding.
And do you believe that the division of the assets that you've agreed to that appear in this consent judgment is both fair and equitable?
Yes.
Is there any chance of reconciliation?
None whatsoever.
If the judge did not sign ultimately this consent judgment, is there any likelihood that you and Mr. Meyer would go back to living together as husband and wife?
No.
Okay. You understand that neither of you are seeking spousal support, and that spousal support will be forever barred, meaning you cannot come back at a later date and ask the court to reconsider that issue. Is that your understanding as well?
That is my understanding.
Okay. You and Mr. Meyer have agreed to opt out of the friend of the court services. Is that correct?
That is correct.
And you signed an advice of rights form informing you of what your rights are relative to opting out of the friend of the court. Is that right?
That is right.
Okay. And is that your desire at this time to opt out of the friend of the court services?
At this time, yes.
Okay. Then you haven't been forced or coerced in any way to sign that advice of rights form?
No.
Okay. You understand that at a later date, either of you or Mr. Meyer could opt back in should you so desire?
Yes.
Okay. And currently, based on the agreement of the parties, child support is not going to be paid in either direction. Is that right?
That is right.
And during the course of your marriage, has there been domestic violence that would in any way cause you to want to file and sign this advice of rights?
There was no physical domestic violence.
Okay, thank you. Judge, I don't believe I have any other questions.
Thank you. Mr. Grote, did you have any questions for Ms. Mayer?
No questions for Ms. Mayer, Your Honor. Thank you.
Did you wish to ask questions of your client?
I would just like to confirm with him briefly, Your Honor.
Sure, please proceed.
Mr. Mayor, please state your full name for the record.
Alexander Stephen Meyer.
Prior to signing the proposed consent judgment of divorce this morning, you had an opportunity to go over that over the weekend. Is that correct?
I did, yes.
And you had an opportunity to ask me questions about the proposed judgment of divorce. Is that correct?
I did, yes.
Okay. And prior to signing it, did you understand the terms and conditions of the judgment as they relate to custody and parenting time?
I do, yes.
Do you believe those terms as to custody and parenting time to be in your children's best interests?
I do, yes. Yep.
And specific to the property settlement agreement, do you believe that those terms are a fair and equitable division of the marital estate?
I do, yes.
And with regard to spousal support, you understand that the waiver of spousal support means that neither you nor your wife can come back before the court and ask for spousal support in the future?
Yes, I understand.
And with regard to the motion to opt out of front of the court services, prior to signing that motion, you did read the advice or rights regarding use of front of the court services. Is that correct?
Yes, I did.
And you understand that you did not have to stipulate to opting out of front of the court services, but you're doing so because you believe it's in not only your children's best interest, but ultimately you and Melinda's best interest presently. Is that correct?
Yes, that's correct.
Okay. And there is no public assistance being received at this point, correct?
Correct.
And you understand that you had a right to a trial before this judge, and the outcome at the trial may have been better for you or may have been worse than the terms and conditions agreed to in the judgment of divorce?
Yes, I understand.
And once the judge receives the signed judgment of divorce, are you asking him to approve it based on the terms and conditions that you have agreed to with Melinda?
Yes, I am.
Okay. Thank you, Your Honor. No further questions.
Mr. Blumberg, did you have any questions of Mr. Meyer?
I do not, Judge. Thank you.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce and will sign both the judgment of divorce and child support order once that's presented. Mr. Blumberg, anything further I can address for your side today?
I don't believe so. Thank you.
Mr. Grove?
Nothing further, Your Honor. Thank you so much.
Okay, Ms. Spillane, was there anything that you needed to add in?
No, sir.
No? Okay, great. Thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you.
All right, Ms. Doak, are you able to hear me?
I am, Your Honor. Thank you.
Okay, great. So we'll go on the record in Rhodey versus Rhodey. This is file number 2520095. If I could have both counsel put your appearances on, please.
Morning, and Your Honor, Jennifer Dusman on behalf of Adrena Rhodey, who's present with me in my office.
Thank you, Your Honor. Jody Doak, who's appearing on behalf of Nick Rhodey, who should be on Zoom with me here.
Okay, and it does appear that Mr. Rhodey is connected. I have this set as a status conference today. I am in receipt of a proposed judgment of divorce. Ms. Dusman-Coy, did you want to proceed with taking proofs from your client and entering that judgment today?
Yes, please, Your Honor.
Ms. Doe?
Yes, sir.
Okay. Ms. Rhodey, if you would please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand, and Ms. Dusman-Coy, proceed whenever you're ready.
Would you please state your full name for the record?
Adrena Amaro Rhodey?
Okay, and you are the plaintiff in this divorce proceeding?
Yes.
And you commenced this action by filing your complaint for divorce on May 22nd, 2025, is that correct?
Yes.
Were both you and your spouse residents of the state of Michigan for at least 180 days before you filed?
Yes.
And were you both residents of Otsego County for at least 10 days before you filed?
Yes.
Your spouse, the defendant, is named Nick Rhodey, is that correct?
Yes.
And you and he were legally married on August 1st, 1998?
Yes.
Where were you married?
Well, with Mansalona?
Okay. And were you married by a person licensed to perform marriages?
Yes.
Your legal name before the marriage was Adrina Amero, is that correct?
Yes.
Are you asking the court to restore your last name to Amero?
Yes.
And that's Amero, correct?
Correct.
All right. You and your spouse have no minor children, is that correct?
Correct.
To your knowledge and belief, are you currently pregnant?
No.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Do you believe that there's any chance for reconciliation?
No.
Okay. And you and your spouse have come to an agreement to create a judgment of divorce, both of you signed that and you're asking the judge to enter that today, is that correct?
Yes.
All right, as to spousal support, you are going to receive $1,000 a month in spousal support for 10 years, is that correct?
Yes.
That's going to begin on November 1st of this year, is that correct?
Yes.
This is non-modifiable support, and you and I discussed that means that that amount cannot be changed for any reason. Is that your understanding?
Yes.
And any further spousal support after that amount of money is paid is barred. In other words, you would not receive any more or any less child support than that, and you could not ask the court for something different. Is that your understanding?
Yes.
Okay. Again, are you asking the court to enter a judgment of divorce and the uniform spousal support, or I'm sorry, yes, the uniform spousal support order?
Yes.
Okay, thank you. I don't have further questions, Your Honor.
Thank you. Ms. Doak, did you have any questions for Ms. Rhodey?
No, just to point out that I think it was an error, but the last time that she meant to say spousal support, she said child support.
I did mean to say spousal support.
Okay. All right. Thank you. Ms. Doak, did you wish to take any testimony from your client?
I would, yes.
All right, Mr. Rhodey, if you can unmute and turn on your camera, please.
I'm not able to see how to turn my camera on. I apologize.
Okay. Can you raise your right hand and let me know once it's raised?
It is raised.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand, and Ms. Doak, please proceed.
Thank you. Mr. Rhodey, have you had a full chance to review the judgment of divorce?
Yes.
And do you agree to all of its terms?
Yes.
And as a part of negotiating that judgment of divorce, you had indicated to me at one point that you did not want to do further discovery or try to hire experts to value some of your assets. Is that correct?
Yes.
And so you decided to proceed with a judgment of divorce in lieu of hiring experts and going to a trial, correct? Are you there?
Yes.
Did you hear me?
Yes. Yep. Yes.
Okay. All right. And that is your agreement that you've placed on that is in that judgment of divorce. Is that correct?
Yeah.
Okay. That's all the questions I have, Your Honor.
Thank you. Ms. Deuce-McCoy, did you have any questions for Mr. Rhodey?
No, thank you.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties here this morning. The court will grant the divorce. I've signed the judgment of divorce as well as the uniform support order and the order for the name change. And so those will be entered with today's date. Ms. Dukes-McCoy, anything else I can address for your side today?
No, thank you, Judge.
Ms. Doe?
Nothing from me, Your Honor.
Okay, thank you. That's all for today. And all parties on this file are free to disconnect at this time.
Thank you.
Okay, looks like we have all counsel joined in, so we'll go on the record in Jones versus Munson. This is file number 2319251. If I could have counsel put your appearances on, starting with plaintiff.
Jennifer Sikorsky on behalf of the plaintiff. Good morning, Your Honor.
Good morning, Your Honor. Ralph Falatudi appearing on behalf of Doctors Murphy, Minor, and Kiley.
Good morning, Your Honor. Jenna Wright Greenman appearing on behalf of Munson Healthcare defendants.
All right, we're on the record here today for defendant's motion to adjourn. Mr. Falatudi, I did have a chance to review the motion and this agreement. And your response as well, Ms. Sikorsky. And so, you know, I guess Ms. Sikorsky, and just correct me if I'm wrong, it sounds like while you're not necessarily stipulating to an adjournment, it doesn't sound like, you know, there's a real strenuous objection, but correct me if I'm wrong on that.
That's correct, Your Honor.
Okay. All right, so I've had an opportunity to kind of go through which the parties will be receiving that trial preparation order here in the next day or two if you haven't received it yet. And in the process of going through that and reviewing our last hearing where we talked about just trial preparation and how long we thought things were going to take, and just looking at the case in general, it's my view that while I certainly don't want to adjourn a trial that is, from my standpoint, pretty much ready to go, that the court has already set aside time for, I don't really want to do that, but given the nature of this case, given the fact that based on the court's docket, there really is no opportunity to go longer if we need to do that. I think it wouldn't be in anybody's interest, including the defendants, the plaintiff, really, and certainly the court and the jury, and the expense that the court will be incurring, and by extension, the taxpayers of Otsego County. I don't think anybody would be well served by getting partially through this trial and then having to figure out how to go from there and start things up. And I just don't see a workable solution if it goes long. And based on what counsel all had to say during our last hearing, I suspect that it's reasonable to assume that there's a fair possibility that it could go long, and I don't want to run into that. So even though I'm loath to adjourn the trial, I do think in the interest of being prudent here, it's probably a better idea to set this for 2 full trial weeks, 10 days of trial as opposed to 7. So the court will grant the motion to adjourn. The court will reset the trial dates with 10 days of trial. Mr. Falatudi, if you would prepare an order that reflects that ruling of the court today. I know the parties, you know, we've obviously got a lot of motions in limine. I don't think that's going to really change. So my plan is to go forward and still rule on those by written opinion, as I had indicated previously, following the additional briefing that the parties had an opportunity to do. I know that we still have this issue of written voir dire, and I got Ms. Sikorsky, your side's response to that as well. So that's something that I'll deal with along with the other motions. I don't think I need to hear further argument on that. We kind of hashed that out during that last hearing as well. So I'll rule on that as part of the other motions in limine. And then the court will set this for another, final status conference prior to the trial date, where we can discuss any issues that have arisen between now and then. But otherwise, it won't be my intention, other than that final status conference, to set hearings prior to the new trial dates, unless requested by any counsel. So with all of that being said, Ms. Sikorsky, is there anything else I can address for your side today?
I have nothing else. Thank you, Your Honor.
Mr. Falatudi?
No, Your Honor, you were very thorough.
Okay, thank you, Ms. Greenman.
Nothing further, Your Honor. Thank you.
Okay, great. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thanks,
Thank
Judge.
you.
Have a good day.
Thank you. All right, there in Sheboygan, can you guys hear me there?
Yes, we can, Judge.
I can. Good morning, Your Honor.
Okay. There in the courtroom is that Mr. Ashenfelter in the courtroom?
Yes.
Okay. Is there anybody else there to participate that needs to be identified in the courtroom?
The friend of the court is here, Judge. Our friend of the court is in the
Okay.
room. Kyle Ortiz.
Can you say that again, the name?
Kyle Ortiz.
Okay.
Friend of the court.
All right. And Miss Fenlon, Megan Fenlon, can you tell me your role, please?
Yes, Your Honor. My name is Megan Finland, and I am Morgan Ashenfelter's mother.
Oh, okay. Sorry, I was looking at the last names there. All right. So you're the plaintiff. Okay. And Ms. Ukala, you're appearing on behalf of Ms. Fenlon?
That's correct, Your Honor.
Okay, good. Thank you. And then just there in Sheboygan, just so that you're aware, I'm recording this. Our jabs as well. I don't know if you guys are recording also, which is fine.
Yes, Judge, I'm recording.
Okay, great. So we'll go on the record then. This is file number 11-9489-DM. This is a Sheboygan County case. I'm presiding over this matter now by assignment. And so all the parties are present. Mr. Kyle is present on behalf of, again, Ms. Fenlon. This is a hearing set today. There was an ex parte order that was entered regarding the custody of a minor child in this case. That order provided that Mr. Ashenfelter could file an objection within 14 days. He did file that objection. And so this is a limited hearing today, solely for the purpose of determining whether this order should remain in place pending a full evidentiary hearing, or whether there's cause to terminate the order at this time. Mr. Ashenfelter, I did receive your objection that contained some pretty detailed notes. I'm assuming that you wrote all those notes in on there, is that correct?
Yes, Your Honor.
Okay, so I had a chance to review all the handwritten notes that you had placed in there. Was there anything else that you wanted to say today in support of why you think this order should not continue?
Just basically, in today's world that we live in, the stuff that Morgan had mentioned, I signed up to be a father, many years ago, and I've stayed true to it through all of it. There's no winning against this county. There's a lot of people against me. And as far as the allegations that Morgan has presented, there's no documentation. There's nothing written. There's nothing texted, emailed. There's no witnesses claiming these items. And Megan has Morgan right where she wants her. And Megan is very vindictive to me. I have followed everything per the custody agreement. I don't give any hassle with front of the court. Front of the court almost doesn't even know who I am. I stay on top of stuff. There was a very troubling past where I finally came out of it. And again, I had front of the court, state police, counselors, all asking, why am I here? I'm very saddened. My family is very saddened over this whole thing. I understand she's a child and I'm forgiving of it. I do not hold Morgan to I've never lashed out to her. The court has basically, back in 2019, 2020, scared me beyond belief of just raising a child, that I would never raise my voice to her, and stuff where even Judge Barton said times are changing. I'm very embarrassed to be here. I'm embarrassed to wasting the court's time. And I know Morgan has till she's 16 to decide, but I can show you, and where I probably was the most hurtful thing is where Morgan says that I take photos showing that I'm a caring dad. Like I said, not only do I, I'm in my 25th season for the Department of Natural Resources as an officer there, and then also coming in my 24th season as a registered official for volleyball and basketball. I am well known around community, and no one would ever, I would challenge anybody to come before the court to state who I am to what Megan and Morgan have placed upon us this morning.
Okay, all right. So I guess one of the things that came through, and I come to this, Mr. Ashenfelter, from a really unique perspective, because I don't know you. I don't know Miss Fenlon. I certainly, don't know your daughter, Morgan. I don't know really anything other than what you've written and what Ms. Pala wrote in their motion about the background of this case or the history or anything else. So I really come to this with kind of a fresh perspective without any kind of prior knowledge of what's gone on between the two of you and your daughter. The main question I have for you that came through to me in looking at your responses and the documents that were submitted is the affidavit of your daughter, Morgan, where she, pretty strongly indicates that she's having some issues in terms of your parenting time. And so, if we set aside everything else, and I know you've indicated, and it certainly came through in your handwritten notes, that you feel that you haven't gotten, for lack of a better term, a fair shake from the court system there. And I understand that you feel things have been manipulated by Ms. Fenlon. But if we put all of that aside, is it your view that Morgan, in her statements in her affidavit, has been so influenced by her mother that she's making up, and I'm not talking about the factual things, I'm talking about where she expresses her own personal feelings about it. Do you feel that she's been so influenced by Ms. Fenlon that she would be willing to make up those feelings and those pretty strong things that she stated in there? Is that kind of where you're at with it? You don't feel that these are her true feelings?
No, it's kind of like a two-part question. No, I don't believe those are her true feelings. I think Morgan is coming to a point of a teenage life, and obviously, some things are more important than family. And what I tell Morgan, as far as, like events and stuff like that has happened, that I don't have to, but I do work. I still work with Megan, even though I shouldn't. I should probably just work with the front of the court, but that's a needly process. I pretty much have focused my time through Morgan, other than a really bad situation where she got caught up into a big lie during Fair Week, such as where the last custody case that dragged on for pretty much the year of 2019 and the mid 2020 was that if something comes up that we know of, we can rearrange, such as like homecoming football would be one, that if it's during one of my weekends, that maybe I can substitute that date for a different date. As far as the emotions and the feelings that she addressed, that has not been noticed by any family member or any person of the community or anybody that if what I want to say is when I have Morgan, we're larger than life. We travel a lot and we see hundreds of faces and no one would ever indicate what she stated in in her statement. I've always looked at what's in Morgan's best interest. As far as custody time, she didn't ask for any of this to happen. That was something between her mom and I. And I don't want to go into that drama, which is part of the non-fair shake of the community system involving herself and Ron Fenlon being the DARE officer. But I've always looked at what was in Morgan's best interest. And at times I hold her higher than a child as far as being able to explore. But at the same rate, there's certain decisions that, you know, she is still a child and doesn't have the adult mindset where she's learning yet, such as like driving, making decisions for future career, stuff like that. She's caught in between the balance of she's still a kid some days, and then literally there's sometimes where I face it, you could say that she's more mature than I am. It's also embarrassing, like when I go to events, people ask who's the girlfriend, and I said, come on, that's my daughter. There's times where she looks quite older than what she is, but she's still a kid at heart, and I enjoy the kid at heart. This is just a bad, I don't think Morgan understands the legal system, and she's persuaded by her mom, because every time I've come before the courts, I've never won, and I'm not looking to win, but I always lose ground every stinking time. And I'm to the point where I can't lose much more. And I truthfully, you know, I hate saying this, but I have wondered if I should have done the bad thing of walking away from her. When this whole thing shook out, when I showed up at Ron's doorstep, after I got served divorce papers on my birthday. Like I said, Megan is very vindictive. She addresses papers, not this last time, but she's served me papers at work, which is kind of embarrassing when you're in your full officer uniform during holiday visits. I've got nothing good to say about Megan, but I don't attack her. There's nothing that can change her. A leopard can't change her spots. I try to keep my head down. I keep my mouth shut. And I try to push forward. And it's very difficult. I don't want to brutalize the system, but as like how you were pointed to, you know, it's kind of the last one Aaron said, I'll tell her to shut up right here in court. But it's not fair to you, you know, because Aaron is her boss that she goes to. Currently now, her former attorney is now the judge as well. I had Dan Martin in the past, and he said some strong words regarding Megan. Martin and Ektal were in the same building. They would talk back and forth. And I can't change the past. I can't even say I can route the future. I just try to keep my nose clean and go forward. And this was a huge blow over the deck, you know, that sunk the ship. It's hard to see this coming from Morgan, but it wasn't just an attack on me. It was an attack on my entire family, my brothers, my stepmom, my dad, which they don't even want to be here because they're afraid of their emotions. And like I mentioned, Megan simply serves Morgan as a pawn and has her right where she wants her. Because it's not about Megan or Morgan, it's about Megan. And I'm the one that always pays. But I stayed in her life. And I really wished, if I knew her and Ron was stuck together, if I could go back to 2012, I'd have done the unhonorable thing of walking out of Morgan's life. So that way we wouldn't be here today. Because I haven't even raised, I don't even, the court stripped me 5 years ago from showing any emotion. That I don't even flirt with it. I don't even try to show aggression. I don't even try to show my frustration. I just go with it. And whenever Megan's upset, here I am. I've given Morgan everything I possibly could for what I have. And I still do. And I'm a forgiving father. I know she's just mad because she thinks some things are more priority than others. And like you read, which I'm thankful that you read it, it was a mutual agreement between Megan and I that the job would not interfere with my visiting time. And as I stated in there, there's never been a time where I denied to take her to work. I just asked the simple question of, how come your dates always interfere with our time? It makes it really hard when you have planned trips to the UP and then she's got to be back to serve ice cream for a couple hours. When previous that week, Morgan had a 4-day event where Ron, Megan went to Traverse City for conference and she headed off, no problem. I always looked at circumstantial evidence, always outweighs testimony. And there's no evidence into what Morgan has stated in my observation and everybody that's been around me. And like I said, it's not a closed community. I travel anywhere from Mackinac Island, Beaver Island, from Grayling to Sault Ste. Marie. And you can pull anybody aside to ever ask if I'm an a-hole. And I'm not. Everybody loves me. I hold that integrity in my 2 occupations that I am just to make ends meet. I just think Morgan is confused, doesn't understand the court system. And as the biggest blow, like we had mentioned about the family dog, that was hurtful. That I told my ex-wife that Morgan could contact her, even though I haven't contacted her in over 4 years. She would be willing to admit I had never murdered the dog as indicated the lines that were fed to her on Megan's side. And I can only imagine all the stuff that Morgan has told. But she has never, maybe there was times where it was lied that Morgan was sick, that she didn't show up to my house. But Morgan, we go toe to toe. We're never isolated from each other. We're always in sync. Like I said, the hurtful thing was when she says that I take photos to prove that I'm a great father. I would say I have 500 plus photos of Morgan in frame, and not one of them shows her being upset, angry, miserable. It's a kid at heart having fun. And especially this time of the year, this is like our greatest time. I mean, we are hitting every apple orchard. We're going to haunted houses. We're traveling to Mackinac and Beaver Island for sporting events. We hang around a lot in the community. We do not sit at home. We are traveling. We missed a good truck show during this whole thing when it shook down. I always plan events for Morgan. We don't just sit around and do nothing. I don't know what you want to hear from me. I just, other than, like I said, I'm embarrassed that I'm here. I'm sorry Morgan felt that way. I don't think everything that was written in the statement was from Morgan. I think it was persuade. Like I said, in the world that we have, she's had an iPhone. Megan can answer better than I can. I think she's probably had an iPhone for a good year and a half. For some reason, it seems like it was around a Christmas item. Never in any text message will there be anything of hatred. There's always, I love you, how you doing, care for you. She, you know, I could say that, you know, she could post any photos, you know, to show anything that would, can't think of the words, honor the statement. But there's nothing in those statements that can be proved. And I was a kid too, in a legal mess like this. And sometimes some things are bigger at life than what you think. And everybody thinks, you know, prom this or homecoming that. And in reality, when you graduate, it means nothing. It's where you're at, where you're going. I don't, to the knowledge that Morgan brought before me, I've never denied her. I do know that homecoming was probably during this time frame, but it was not brought up. And Megan has always made the decision of travel soccer programs, summer camps, other events. And sometimes I'm always hit with that week, like, oh, hey, by the way, and it's like, you know, what can you say? Like, okay, so I'm the a-hole if I say no. And I don't, I go with it. I get it, you know, kids got to go places. I do what I can with what I got. I am stretched so thin. It doesn't matter between money and time. I have nothing. And when Morgan's over, I tell her, this is not how I live. I give her 100%. And then basically when she's gone, it's bologna sandwiches after that. I'm not dissing some of the people in the courts. Chappelle was sitting there shortly after when Megan had to come and take items out of the house. I know a lot of people in the community, a lot of people in this community think I'm actually dead because I sheer far away from Sheboygan, that I am off the grid to these people. There's just some people that have done the worst, and here they are as their officers, here they are as undersheriffs. I don't get it. And congrats to Megan. She's got the best attorney, I think, in the county. And she can't take her former attorney because he's the judge. And she has a lot of connections, a lot of pull. Wherever she's mad, she walks across the hall or goes upstairs, goes to the front of the court, and then I get slapped with papers. The front of court can say I've never gone to the front of court arguing against Megan. I've always been responding and on the receiving end. And I don't ever intend to cause any wake against Megan. But yet I don't know what Megan wants. If she wanted me out of Morgan's life, she's doing a fine job of doing it. I came here as responding to what was said. I had nothing to know what was going to happen. Other than the isolation game is huge. Having Morgan not around for over a month, in which I have not, the last time I texted her was after I received notice from Jeff Burr. I have not communicated with her because that's her strategy, hoping I'd screw up and slip, that I would contact Morgan and they would slap me with papers of a no contact order. It's the same event they tried pulling for 5-6 months back in 2019, 2020. And I've held resilient, never lost my cool, and they hate it. Because it only takes one word, one slip up that I could change it. And Megan's over there pumping her fist saying, yep, he did it. He finally screwed up. And like I said, I'm an open book. You can ask the entire community to come before me to testify against me. And nobody will. Because it's the truth. I'm not, have I got slammed in the past? I did. And I've asked several times, was I completely in the wrong? And a lot of people say, no, it's what we did. I don't get why it is. There's schools, there's Christian schools, there's Catholic schools that are still spanking and swatting. There's still households. I'm sure everybody in this household got spanked, or everybody in this courtroom got spanked or has spanked their children. And that was the big turning point. I asked Morgan if she was, we had gone back and talked about it. And she has no regrets. I wouldn't say regrets. That has not been troubling, which thankfully she wrote that in that statement, that I did not go back to that. Because giving a child a spanking or 2 times a month cost me over 10 grand in lawyer fees, court fees, counseling sessions, drug analysis. I've never taken anything in my life. And I just wish the court could be more like that, where it's like, hey, go take a drug analysis sample, come back clean, good to go. I'll do that every stinking day of my life. And they can't ever find falter in me. I would live, I'd hate to say it, but I'd live with an open camera in my household to show I am not aggressive to Morgan. I'm not abusive to Morgan. I don't say nasty things to Morgan. I'm simply a father looking after his daughter. I am very protective of my daughter. Morgan knows with not just my experience with the community, but with Ron and Megan's response to the community. Morgan knows that sometimes, we may tell her to, hey, hush up and just follow me, because there's somebody here that we may have arrested, somebody that we might have taken to court, somebody that's on our profile list, that just follow us, walk in, walk out. It's the life that Morgan has to live with her family in law enforcement and SAPA and stuff like that. She gets it. I love Morgan with all my heart, always have. I know it's not Morgan. Family knows it's not Morgan. Just Morgan's probably having an off day because she got told no. And she knows the system. She's persuaded highly by her grandma. And I could only imagine, I hate Ron with a passion. I think Ron and I have only spoke a handful of words since this all happened in 13 years. But I don't hold nothing against him. I don't, I think Megan strictly is the person. Ron, I would assume, just keeps his mouth shut and nods. I thank him for probably being a father role for Morgan. A lot of people have told me that too, that Ron is a good father figure. He's going to be in the school right there as a dare officer, so I know Morgan's okay. But I have no beef with Ron. Ron, I would assume, has no beef with me. Like I said, we've never talked. When they got COVID, I said thanks for a drug or a COVID test. When they both got COVID, I didn't wish the worst on them. I hope they pull through it. We don't speak to each other. We have no reason to speak to each other. I hate to communicate with Megan. It's a last resort that I have to. But normally I do not reach out to Megan. Any text is just because I have to. Because we don't want to channel through the front of the court. And that's simply just rotating days out as to if we could switch weekends. I'd like to say that I've always bent over backwards for Morgan's best interest. Despite it's on the fly, on the spot. Like, how do you coordinate something that you've already had plans and then the other one says, oh, by the way, this is going on. I have
Okay,
lots of.
I don't want to cut you off, Mr. Ashenfelter, but you're kind of starting to go over kind of the same ground, just in a different way. So I think I understand what your point is. I'm going to hear from Ms. Zucala, and then I'll give you a chance to speak again. Okay.
Thank you.
All right, Ms. Zucala.
Your Honor, first, I find it very interesting that Mr. Ashenfelter made the comment that Morgan comes, I think he said Morgan comes, or the parties come from a very troubling past. I agree, there's been a troubling past here, and that troubling past is solely as a result of Mr. Ashenfelter physically abusing his own daughter. We're not talking about just a spanking here and there. We're talking about him using several objects to physically discipline his daughter on numerous prior occasions, which he admitted to: a spoon, kindling from a fireplace, and a cutting board. Those disciplines resulted in him being charged with child abuse against Morgan. Ultimately, he entered a plea to domestic violence against Morgan. It was as a result of those incidents that initially triggered some panic attacks in her, that have triggered sadness and depression in her. There was a period of time where she didn't have contact with her dad as a result of that criminal charge. That wasn't something she did. That wasn't something that Miss Fenlon did. That wasn't something that Miss Fenlon's husband, Ron Fenlon, did. That was something Mr. Ashenfelter did. As time has gone on, Morgan resumed contact with her dad, but the feelings that she had as she's gotten older had become stronger and stronger. I understand that Mr. Ashenfelter wants to come to court and he wants to point the finger at my client and he wants to say that Morgan is saying all of this because her mom told her to, or because her mom has been trying to alienate her against her dad. Or as he just said to the court a few minutes ago, Morgan probably had an off day and was told no by him. Morgan didn't have an off day. It's been approximately a month since the court's ex parte order was entered, and Morgan's not trying to initiate any sort of contact with her dad. And the reason for that is the reasons that were stated in the affidavit provided by Morgan to the court. The court should be well aware, and frankly, Mr. Ashenfelter should be well aware that when this motion was filed, Ms. Fenlon contacted me and requested the opportunity to come speak with me with Morgan about how Morgan was feeling. This was almost immediately after Morgan had gone to her mom and told her that she was having suicidal ideations. Ms. Fenlon contacted me and said, you know, it's really important that I get in to see you and I get in as quickly as possible. We need to talk to you. This is serious. And frankly, I sort of underestimated how serious it was until They came to my office. I asked Morgan to talk to me about how she was feeling. She asked if her mom could be excused from the room so that she could be completely frank and honest with me outside the presence of her mom, because I think she was worried about how her mom would feel if she heard how Morgan was really feeling. And she laid it all out there for me. She told me exactly what's contained in her affidavit. She told me how she was feeling. And at the end of that conversation, I said to her, I'm going to file a petition with the court, but I have to talk to your mom about how you're feeling because we need to get you in to talk to a counselor and address these feelings immediately. The last thing I want is for you to harm yourself or continue having to see a person that's causing you to feel this way. I talked to her mom. Morgan gave me permission to do so. I talked to her mom. We resumed her counseling with Thunder Bay immediately. It is my understanding that Morgan's now been in counseling over a month. She resumed it at the beginning, or excuse me, end of August, immediately after Morgan made these disclosures to her mom and to me. It is my understanding, and Ms. Fenlon can elaborate more if the court needs her to, that the counseling has been extremely beneficial to Morgan. Both the counselor and Ms. Fenlon have seen drastic improvements in Morgan's demeanor, in her behavior, in her general outlook on life. I can tell the court that the counselor has represented that Morgan should not be having contact with her at this time, that she is benefiting from counseling, but that this is something that's going to take a while for her to work through. And frankly, at this point, I'm not concerned about what Ms. Fenlon wants or what Mr. Ashenfelter wants. I'm concerned about Morgan's safety and her well-being and what is best for her mental health. And at this point, what is best for her mental health is for her to continue not having parenting time with her dad. That's based upon the opinion of the mental health professional that she's been meeting with consistently, who's been working with her and who Morgan has developed a relationship of trust with. I can tell the court that every single statement contained in Morgan's affidavit to the court was based upon a representation that Morgan made to me personally, outside of the presence of her mom. And I truly believe that the things contained in that affidavit are how she feels. And I'd also like to believe that Mr. Ashenfelter, to a degree, recognizes that those statements are true, because